and the coordinator of CNPA. If this is your first time with us, you will probably hear me again if you come back for more webinars. I am very happy to welcome as well Isabel Grant and Janine Benedet, who are both professors at the Allard School of Law at UBC in Vancouver, and who are going to host this webinar about the criminal justice system responses to the sexual assault of older women. Now, before we get started with the actual presentation, I just want to start us off with a few reminders regarding the platform that we are using today. So, a couple of tips. All of you are either using the online audio system or are listening to us via phone. So, if you're listening online on your computer, please ensure that your sound is turned on. It sounds silly, but it can happen not to notice, and that it's turned up all the way, and that you have plugged in your headphones properly. If you're still hearing some slightly echoey sound and it's really a problem to understand me, let me know by using the chat box that you see on your little control panel. If you're using your audio via phone, clearly you have already connected, but just in case you need them again to try again, here are the numbers you can use if you're calling from Canada or the US. Access code, and the PIN shows up on your screen once you have joined the training. I am currently recording this presentation as always, so this is a reminder for all of you. If you are listening to this presentation on your computer, you can mute yourselves by clicking on the little microphone icon. And if you are listening via phone, you can either use your mute/unmute button on your cell phone or your regular phone, or press *6 on the keypad. All of these will help mute you so that we don't have any background noise during the presentation. If you're running into any serious tech issue, the best way to go about it is usually to just shut everything down, unlog, and come back online. But if something is still up, do not hesitate to use either the chat box or to send me an email directly at this email address that you see on your screen right now. What else? Yes, if you have a burning question, fear not, there will be a question and answer session at the end of the presentation, but you can type in your question in the chat box at any time during the webinar, and I will make sure to cover them all at the end. And if we don't have enough time to cover all of your questions, the email addresses for both Janine and Isabel are going to be appearing on your screen in the next slide, so you'll be able to contact them directly. Their contact information is also on cnpa.ca. And as I said, the webinar is recorded, so if you cannot stay until the end, or if you know someone who wanted to attend but missed it, as long as they registered for this webinar, they will receive a link by email tomorrow that will be the full recording of the presentation. We'll also be uploading this recording to our website shortly after that. And finally, this webinar is part of a greater project, a 3-year-long project, during which we're going to be hosting a number of webinars around the topic of increasing access to justice for older victims of sexual assault. So it's always very important to us to know that we are hitting the mark and that we are providing you with the information you need and you're looking for. So in the next couple of days, you'll receive an invitation to take a short survey about this webinar, and we'd love it if you could take a few minutes to respond to the questions and let us know how we're doing, because it really helps us for the next planned webinars. Okay, I believe this is all when it comes to tech announcements. So let's introduce our presenters today first. Isabel Grant, Professor Isabel Grant's interests lie in the areas of criminal law and violence against women. She is particularly interested in the law and policy issues surrounding male intimate partner violence against women, sexual assault, homicide, and HIV non-disclosure. She is currently working on a SSHRC-funded project on sexual assault across the lifespan and teaches in the areas of criminal law, sentencing, homicide, and mental health law. Isabel has worked on a number of Supreme Court of Canada interventions with the Women's LEAF, so Legal Education and Action Fund, and CACL. And as I mentioned earlier, you can always get a hold of Isabel at grant@allard.ubc.ca. Janine Benedet. Professor Benedet's areas of teaching expertise include criminal law, labor law, the law of sexual offenses, and legal ethics. Her current research focuses on sexual violence against women, including prostitution, pornography, and sexual assault. She is currently researching the barriers to successful criminal justice system responses to sexual assault for women and girls across the lifespan with Isabel, as well as the use of criminal law to target sex buying and pimping. Janine is an associate editor of the Criminal Reports, and you can get a hold of her at Benedet at allard.uvc.ca. Now, I'm going to Isabel and Janine. I'm going to unmute you just so we can actually hear you. Give me just a second, and I will let you take over from there. Janine, you're now unmuted, and Isabel, you're now muted. And Janine, you're going to be made presenter right now. Take it away.
Great, thank you very much. This is Isabel Grant. I'm going to begin, and then I'm going to switch it over to Janine, and then we are going to change again once. So we'll let you know when we are changing speakers. I first just wanted to thank everybody for participating in this webinar today, because we really appreciate the opportunity to share our research with you and hopefully to learn from the questions from you at the end of the session. Over the past year or so, we've seen increased public awareness about the pervasiveness of sexual assault. The Me Too movement has highlighted the degree to which sexual assault is a problem in virtually every part of women's lives, at home, at work, in sports. There's really no part of women's life where sexual assault is not, or the threat of sexual assault is not a serious problem for women. And we've also seen increasing attention in Canada to the inadequacy of the Canadian criminal justice system in its response to sexual assault, virtually at every stage of the process, starting with the problems around reporting to police, all the way through to the trial stage in the small number of cases that make it to trial, where women are subjected to grueling cross-examinations about virtually every aspect of their private lives. Yet at the same time that we've had this increased awareness over the past year or so, we haven't seen the same awareness with respect to older women. The Me Too movement has focused largely on younger women and girls, and hasn't really brought older women into the picture, except to the extent that older women sometimes report sexual assaults that happened to them when they were younger. And this is despite the fact that we know that sexual violence is something that older women face, and particular groups of older women are particularly vulnerable to sexual violence. So what we sought to do in this project was to bring older women back into the conversation about sexual violence. So I'm just going to give you a bit of an overview of what we're going to do in the webinar. First, after a brief review of how we came to this project, we're going to give you an overview of sexual assault law in Canada and the challenges of applying that law to older women as complainants specifically. Next, we'll briefly review the scope of the problem from the social science literature, which groups of older women are most at risk, who are they at risk from, and what happens when these cases actually make their way to the criminal justice system. Then we will move on to present some of the results of our case study, in which we looked at 20 years of case law involving sexual assaults against older women in Canada. And then finally, we're going to discuss the discrepancy between the picture painted by the social science evidence and what we saw in our case law, and how we explain that discrepancy in terms of what kinds of cases are making it to the criminal justice system and what happens to them when they get there. And as we will discuss throughout the webinar, what's really notable about these cases, and a lot of the things we learned, is what is not in the case law. So what can we learn about sexual assault against older women from the cases that we are not seeing in the criminal justice system? Now, our collaborative work began about a decade ago as we started looking at sexual assault against women with mental disabilities. This was another area where we found there was a discrepancy between what social scientists were telling us about what was actually happening in the world, which was that women with mental disabilities were particularly vulnerable to sexual assault, and what the case law was telling us, that these women were only very barely represented in the case law. And so we looked at a number of issues regarding women with mental disabilities, things like the tests for capacity to consent to sexual activity, and when a woman with a mental disability could testify and participate in a trial of the person she has accused of sexually assaulting her, and how they stand up to cross-examination. And we soon realized that the category of women with mental disabilities had significant overlap with the category of older women. Younger women with mental disabilities themselves age and become older women with mental disabilities, and some women develop cognitive disabilities for the first time in later life. And we realized that many of the topics we were looking at around capacity to consent, for example, or the ability to testify at a trial also had relevance for older women. We also started talking at this time about the fact that sexual assault isn't something that only happens at a particular point in a woman's life. Rather, there's a cumulative impact of sexual violence and of the threat of sexual violence across the lifespan. So in other words, older women who experience sexual assault as older women may well have faced it as girls and as younger women as well. And that the lifelong exposure to sexual violence had an impact on how women experience sexual assault. And this is what led us to decide to enter into this lifespan project, and looking at the barriers to effective prosecution at different stages of the complainant's lifespan. So from adolescent girls to women in midlife to older women. And that's really what took us to the present project. Now, we know, of course, that older women are not a homogeneous group. In fact, the category of older women includes women living in very different circumstances. So, for example, some may be experiencing cognitive decline associated with age. Others may have physical disabilities. And many older women don't experience any disability at all, but may be marginalized for other reasons related to, for example, poverty or social isolation and ageism. And we also recognize that this group of women live in a variety of circumstances that might have an impact on how they experience sexual assault. The majority of older women, a large majority of older women, live in the community. Some live in supported housing, such as a seniors apartment building, and some live in long-term care. Some older women, as we found in our study, are homeless and do not fit into any of those categories. So what we found was how women experience the ongoing risk and harms of sexual violence are shaped by these kinds of factors. Now, I just wanted to say, too, that by focusing on older women, we're not suggesting that older men do not face sexual assault as a function of their age and life circumstances. But the reason we are focusing on women is because sexual assault is a gendered crime across the lifespan. And that fact exists also for older women. These assaults are overwhelmingly committed by men. We didn't find, for example, a single case of a sexual assault committed by a woman against an older woman or an older man. And our findings confirm that sexual assault continues to be gendered from the stage of children, adolescents, all the way through to older age. Now, at the outset of doing this work, we had to make a couple of decisions. First, how were we going to talk about the group of women that we were trying to study and look at how they experience sexual assault? Were we going to describe them as old or older or elderly? And we thought that the choice of label might also shape the second question, which was, who is included in this category? So first, with respect to language, we figured out pretty early on that calling this group of women old would have certain pejorative connotations and also stereotypes about who was included in this population that we did not want to invoke. And I think most importantly, the women we were interested in looking at were not necessarily old by traditional measures of who we think of as old in society, but rather they were older as compared to other sexual assault complainants. And this is why we've landed on the language of older women. We felt that this comparative reference point was particularly appropriate for sexual assault because it's our social construction of age and of female sexuality that makes these women seem older, even though chronologically we would not describe these women as old. In other words, we think that women are older at a younger age for the purpose of sexual assault than for many other purposes. And so flowing from that, we decided to use a low cutoff in terms of the age of women we were looking at. And we decided to look at sexual assaults against women who were 50 years of age and older. And again, we want to stress that we're not suggesting that a 50-year-old woman is an old woman, but we are suggesting that for the purposes of sexual assault, she is older than how we conceive and what the case law shows us of the typical victim of sexual assault. Now, I just wanted to say a couple of things about that, because why is it that when we think of sexual assault, our minds automatically go to younger women and girls and not to older women, when we know, in fact, that older women do face a risk of sexual assault? And we think that's connected to this myth or stereotype that sexual assault is about being sexually attracted to someone, that men sexually assault and choose their targets based on who they are sexually attracted to. And so if you see sexual assault this way, it would be understandable if we don't construct socially older women as sexually attractive. We might not expect to see them as complainants in sexual assault. But in fact, if one sees sexual assault as about men exercising power over women who have less power, and if women are targeted because of their vulnerabilities, which both decrease their ability to resist sexual assault and also make it less likely that they will be able to come forward about their sexual assault, then you can see that older women would be an expected target, particularly as their vulnerabilities increase. And this is something that we're finding at every stage of the lifespan, that women with intersecting vulnerabilities are at greatest risk of sexual assault, regardless of what age they are. And while those vulnerabilities may shift somewhat from one age group to another, that fact does not change. So what I'm going to do now is pass it over to Janine, who's going to talk a little bit about the scope of the problem of sexual assault against older women, I'm sorry.
Well, thank you, Isabel. And yes, I thought that what I might do, or we thought that what we might do, recognizing that the listeners to the webinar come from a variety of different professional backgrounds, is just spend a moment or two reviewing in a very general way the realities of sexual assault law in Canada and what happens when sexual assault cases get to the criminal justice system. So I'll just start by saying that in general, a conviction for sexual assault requires that the Crown prove beyond a reasonable doubt a number of things. It's required that the Crown prove that there was some kind of physical contact of a sexual nature that took place. And in some of these cases, that's in dispute, and the accused says there wasn't any contact at all. And that the sexual contact took place without the consent of the complainant. And in Canada, we measure that subjectively according to the complainant's, the victim's state of mind, that she doesn't want the sexual touching to take place. There's also a requirement of intent, what we call the mens rea of the offense. And so it also has to be shown that the accused knew that the complainant was not consenting to the sexual contact. And we typically deal with that under what's called the defense of mistaken belief in consent. And we ask the question of whether the accused honestly believed that the complainant had communicated a yes by her words or her actions. So it's an affirmative consent standard, one in which passivity or a failure to resist or mere compliance is not supposed to be equated with consent. So that's the basics of what has to be proven. The difficulty, however, is that most sexual assault cases really turn on the credibility of the complaining witness, of the woman who's brought the complaint. That's because sexual assault is rarely committed in the presence of third parties, although, as we'll see, some of the institutional cases involving older victims do rely on some other third-party witness to bring the complaint. But most of the time, it really is a question of the complainant's credibility because there isn't any evidence other than her own testimony. And of course, in the criminal law context, it's not just a question of which story is preferred or who is more believable. Because there is a presumption of innocence, because the burden is on the Crown to prove the guilt of the accused beyond a reasonable doubt, the credibility of the complainant is crucial, and it's very difficult to secure a conviction in cases where the only evidence is the testimony of the complainant. As a result of the complainant's credibility being so key, we see complainants being attacked in cross-examination in sexual assault trials, and many of you will be aware of and familiar with that. The notion that defense counsel is going to try to show that the complainant is a liar and that she is confused, that she has brought a false complaint, and that in fact she did consent or that the sexual activity never took place at all. And there's a real risk, as we've seen in many high-profile recent cases, that cross-examination can invoke myths and stereotypes about women and about sexual assault. And one of the points that we want to, I think, highlight in this webinar is that we often don't think very much about the way that myths and stereotypes about women and sexual assault can shift across a woman's lifespan, so that the stereotypes we're concerned about when a woman is 20 may be different than those that emerge sometimes in a kind of stealth-like way when a woman is 70 or 80 years of age. And finally, I'll just note that even though the requirement that the woman's testimony be accompanied by corroboration has been abolished in Canadian law for more than 30 years, it's still very much alive and well in practice. And as I've said, courts tend to want something more than just the woman's word. And again, that presents particular problems for an offense that is mostly committed in private. So when we turn our attention back then to the scope of the problem of the sexual assault of older women, one of the things that became immediately apparent to us in doing this project is that there is almost no Canadian data that is specific to the sexual assault of older adults or of older women in particular. So in large measure, we had to rely in terms of the social science evidence on American studies, on studies from the UK and from Australia. And even those studies present challenges in that they often measure very different things. In some cases, they're measuring people who required treatment in an emergency room for sexual abuse. And so, again, that might only be a small subset. They might focus only on a particular location or on cases involving, sex offenders who were actually incarcerated. So we're often getting a valuable but a small slice of what the problem is. The other thing that's, of course, important to note is that in many cases, the sexual abuse of older adults and of older women in particular is simply aggregated with other forms of elder abuse. And so it can be very difficult, even where we do have empirical evidence about the abuse of older adults, to separate out from that the cases and the instances that involve sexual abuse. And so it's clear to us that there's a real need for further empirical research in this area, and in particular for Canadian research. Having said that, we do know some things that are quite clear and quite consistent across these various studies from different jurisdictions. The available social science evidence that we have indicates that sexual assault against older women in the home is often committed by family members and other acquaintances with whom there may be some relationship of trust. And this is consistent with the pattern for sexual assault generally, which we know is only rarely committed by strangers. For the small number of women who are living in long-term care or other kinds of residential settings in hospitals, most often sexual assaults are committed by staff members or by other residents, some of whom may themselves have cognitive impairments. And the best evidence we have suggests that at least a quarter of sexual assaults against older women take place in residential care settings, even though far less than 10% of adults aged 65 and older live in long-term care facilities. So there seems to be a higher risk or higher incidence of sexual assault in those settings. We also know from the social science evidence that having dementia or other cognitive impairments increases the risk that women will be sexually assaulted. These women may be targeted because they are considered to be less likely to complain and less likely to believe if they do complain. There may also be a sense on the part of some offenders that these women are not fully human and can be used for sexual gratification because they either won't remember what happened or because they won't really be harmed by it. So I'll just say a few words before turning it back to Isabel about what happens when these cases do come to the criminal justice system. What we know overall is that very few cases of sexual assault against older women make it to trial, and Isabel's going to give you some numbers that show how stark that is. And when they do, there are barriers at every stage of the process. We see cases in which the victim is simply unable to report the sexual abuse due to dementia or other cognitive impairments, loss of memory, and the like. We see an incentive on care facilities to try to deal with matters internally as a staff issue or as a resident behavior issue, to avoid publicizing the fact that this place may not be a safe place for older adults. There's pressure on both families and institutions, really, to cover up the sexual abuse of older women. Well-meaning family members and professionals may want to avoid additional trauma to the woman and may discourage any kind of criminal justice system involvement. And the reality is that the criminal justice system is slow. And we saw a number of cases in which women either died or became incapacitated in the interim between making the complaint and the case actually going to trial. And of course, even where women can report sexual abuse, they may be afraid or reluctant to report their own family members, who may in fact be their caregivers, or whom they may be caring for and may have dementia. So for example, the woman who's caring for a husband who is sexually and possibly physically abusive to her, and where that husband has an Alzheimer's diagnosis. We may see extreme reluctance on the part of that woman to get the criminal justice system involved in relation to her own husband, but without that, then she's often left simply to struggle on alone. So we were interested in what cases did make it to trial, and I'm going to turn it over to Isabel to tell you a little bit about that.
Thank you, Janine. So I'm just going to start by telling you a bit about our case study and what we found, and as I mentioned earlier, what we didn't find, which was as interesting as what we did find. We looked at 20 years of Canadian case law on sexual assault against older women, and we gathered every written set of reasons from a judge that we could find, and that included sentencing decisions. Now, we recognize that not all cases result in written reasons. If there has been a jury trial, which is a small minority of cases, or if there has been a guilty plea, there may in fact be no record of that that's accessible to us. But we did add to that list of cases by including sentencing reasons, and also by doing an extensive newspaper search for mention of these cases in the media. So we looked at all cases involving complainants of the age of 50 years or older between 1995 and 2015. So what did we find? We found 111 cases involving sexual assault against older persons. 109 of those cases involved older female complainants, with 2 cases involving older men as complainants. All of the accused persons in these cases were men. Of these 109 cases, so that's 109 accused persons, we're actually talking about 154 complainants, because in several of the cases, the accused person was charged with sexually assaulting a number of older women. So I guess the first thing to say about what we found is just what a tiny number that is. When you think of a 20-year time span, finding cases involving 154 women is an extremely small number. And we have done similar studies with girls and women in other age groups and found rates of cases 20 times that number per year. So that's the first thing to say, is that this is a tiny number of cases that are actually making their way into the criminal justice system that were accessible to us. The next slide that we're going to show shows you a little bit about who these women are in terms of 2 variables, their age and their life circumstances, i.e. where are they living. And you will see that we had women aged 50 all the way through to women in their 90s. We also had some women for whom we didn't know their age, but the judges used words that signified to us that the complainant was over 50. So for example, words like senior citizen or elderly triggered to us that the court must have been talking about a complainant who was over the age of 50. And you'll see that we also found cases of women living in the community, women in acute care hospitals, women in supported housing, and women in long-term care. And interestingly, and I don't think we have a very good explanation for this, the numbers seem to peak for women between the ages of 70 and 90. And this may be in part that our numbers are dominated by women living in the community, and it's possible that women are more likely to be living alone and thus targeted at those ages than they are at younger ages and possibly at older ages. But that's speculation on our part. But you'll see that so 93 of the 154 complainants lived in the community. So that's 60% of the women that we saw involved in these cases were living independently in the community. 14 were living in acute care hospitals. Now that number is slightly misleading because in fact that was only 4 accused people. It was that in one case we saw there was a doctor charged with sexually assaulting 24 women across different ages, some of whom were older and therefore included in our study, and some of whom were younger. All of these cases were committed by doctors or other hospital caregivers. It was difficult to generalize about these cases because the women were in very different circumstances. Some were just short-term in the hospital, others were there more longer-term. 29 of the complainants we looked at lived in some form of supported housing. So this number is also a bit higher than our study actually suggests, because we're only talking about 9 men charged with these cases. And again, what we saw was men attacking multiple women in this situation. And then finally, 18 of the complainants in our study lived in long-term care facility. And that represented 14 accused persons charged. So some of them were charged with more than one sexual assault. So that just sort of gives you a number of, an idea of the sort of group of women we're looking at. Now I'd like to talk a bit more about each of those categories that we used, focusing on women living in the community and women in long-term care, because these cases looked in these two categories looked very, very different, what we found. Now, you'll remember that Janine has said that most women in the community who are sexually assaulted by men that they know. And while estimates vary, I think it's a rough estimate is roughly 75% of women who were sexually assaulted in this age group in the community are sexually assaulted by family members of some sort, largely spouses, but also sons and other family members. That's not at all what we found. We found that 60% of the women we were looking at were sexually assaulted by a stranger, and only 5% of cases involved a family member. In fact, in all of these 20 years we looked at, we found only one case of a spouse being charged with sexually assaulting an older spouse. What we did find with this group of cases is that these were often extremely violent break-ins where often a very young man who's had a very troubled background, sometimes even teenagers, broke into a woman's house, violently sexually assaulted her, and committed a number of other offenses. These were extremely serious cases involving the amount of violence that was used, and the number of the women in this group of cases were killed, and even more lost the ability to live independently in the community. Of these women, only one of them had dementia or any signs of cognitive decline. So just to be clear, we're not suggesting here that the social science evidence is wrong. In fact, what we're suggesting is that our case law study presents a very distorted picture of sexual assault against older women, because what it is showing us is that only these cases are making their way into the criminal justice system. So we're seeing that, and the slides are just a little bit off, so I'm still actually just talking about women in the community, if people can just follow along with that. What we expect then from these cases is that if a man breaks into a woman's home, beats her up, and sexually assaults her, that case is getting reported to the police. And the police will and the prosecutors will prosecute that offense to the fullest extent of the law. If, on the other hand, a woman is sexually assaulted by her husband or her son, she may be too afraid to call the police. She may be pressured by family members not to call the police, or the police may not believe her if her husband or son is denying it. So only a very small select group of these cases is actually making it to court. We saw a very different picture with sexual assaults against women living in care facilities. In this context, 17 of the 18 women involved had some form of dementia. The common thread that tied all of these cases together was that they were brought forward or reported by somebody other than the complainant. So somebody witnessed the sexual assault that was happening, and it was reported to police. Because of the high rate of dementia in these cases, there were no cases where it was the complainant herself who testified and was the one bringing the complaint forward. These cases were largely committed by caregivers. That was the biggest group of accused persons, other residents, and on occasion, volunteers to the facility, including in one case, a priest visiting patients in the facility. Where the accused was a staff person, some of them had assaulted more than one woman, and there were often suggestions in the case law that this was not the first time this had happened, that the accused might have worked for another facility and had to leave that facility in unexplained circumstances, which raised concerns that maybe these cases are not being reported at the rate that they should be. The conviction rate was very high when staff persons were charged in these cases, and again, that was because there was a witness. One can only imagine what's happening in these cases where no one sees what's happening, and these cases are not brought forward. Some of these men tried to argue that what they were doing in sexually touching the complainant was giving them medical care, but that argument was usually rejected. All of the cases we found involving other residents involved men who themselves had dementia. 3 of these men were found unfit to stand trial, which means that no determination of their guilt could be made because they were not able to participate in any meaningful way in a trial. And usually what happens for these individuals is that they end up in a high security psychiatric facility. And in this case, that's probably going to be for the rest of their lives because we simply don't have any way to bring them to trial in the criminal justice system. One interesting thing that we did find was that cases in care facilities generally received lower sentences than where women in the community were sexually assaulted. Now, on the one hand, this made sense because women in the community faced a great amount of violence, whereas the complainants in the care facility cases didn't because they were incapacitated in other ways and were not able to resist. But even where we controlled for that and only looked at cases not involving excessive violence, we found that higher sentences were given for complainant, 2 accused persons who were charged with sexually assaulting complainants in the community. And, you know, one can only wonder whether that is based on the false assumption that women with dementia suffer less harm from sexual assault. And in fact, as Janine alluded to, the literature shows that that's not the case and that that's a false assumption, even if women are only able to express that harm in different ways because of the dementia. There's pretty strong evidence that women suffering from dementia experience the harm of sexual assault very profoundly. Now, the cases of women living in supported housing, these cases tended to look more like the community cases. A man would break into a senior's apartment building and sexually assault a number of women until somebody was able to apprehend him and charge him. And those cases also involved young men who received very serious sentences. So I just want to say, this is the last thing I'll say before passing it off to Janine, who will give you a couple of examples. Why did we find such a discrepancy between what Janine set out from the social science literature and what we found in the case law? And in a lot of ways, what we found is that the case law now dealing with sexual assault against older women very much mirrors the case law for sexual assault generally 3 decades ago, where sexual assaults were only committed by strangers and there was very little awareness of, for example, intimate partner sexual assault. And it was the work of feminist activists and community members who got violence within intimate relationships fully recognized and taken more seriously, although that's still something we really struggle with in the courts. And I think that tells us that we still have a real problem with these cases and that we need to do a lot of work to bring to the forefront the violence women are experiencing in the home from people that they do know, and not just the really extreme anomalous cases involving an accused person who breaks into her home and assaults her. And then finally, the last thing I just want to say very quickly is that Janine talked about the importance of credibility. Older women who are often absent from these cases altogether do not have their credibility challenged in the same way as younger women. And this may be that we don't see older women as sexual subjects at all, and we don't see them as ever giving consent, and therefore we don't have the same stereotypes and assumptions around, are they lying? How the questions around how the woman was dressed or was she drinking alcohol, those questions just don't come to our minds in the same way for older women that they do for younger women. So I'm just going to turn it back to Janine now to talk to you about a few examples.
Yeah, so we thought it might just be interesting, and I know we don't have a lot of time left, and I do want to allow some time for questions, just to kind of give you a few examples of the cases we did find and to contrast them with cases that are out there, but are out there in much smaller numbers. And so I won't spend much time on the first couple of examples, but they're described and the citations for them are available in our published article. But for example, we see a case like Brown, where the staff member is working in a secure unit for residents with Alzheimer's disease and is charged with 2 counts of sexual assault with groping the buttocks of one resident. And this is observed by a family member who's visiting another resident. And then is found much more seriously with a resident who is naked on the toilet, and the accused's own pants were down around his ankles. And we see in this case a very sort of common pattern where the caregiver says, well, this was all done in the course of care. The reason that my pants were pulled down is because the resident pulled them down, and attempts to give that explanation. And this was a case in which the accused was actually acquitted on the first count, because it wasn't entirely clear to the judge what had happened in terms of the groping, but convicted in relation to the much more, I think, damning evidence of the second complainant. And we also saw cases like the decision in Dallas, and these were the break and enter cases that were so horrific and yet are not really the typical sexual assault. So this is a case in which the complainant is 88 years of age. She's living alone in a small island community in British Columbia. And the 38-year-old accused breaks into her home, rapes her at knife point, assaults and robs her, and threatens her not to tell anyone. And we saw in this case, as in many that fit this profile, that the complainant lost her independence as a result of this sexual assault and was no longer able to live alone because of the extreme physical and psychological consequences of this sexual assault. And these are cases in which the offenders tend to get long sentences of imprisonment or to be designated dangerous offenders. But what we rarely see in the case law are cases like the case of Lee, which fell outside our time period for our survey, but which took place last summer in British Columbia. That was a case in which the complainant was 97 years old. She was living in the community with her family, and she reported that a 61-year-old neighbor who was visiting had kissed her and groped her and put his hand in her underwear. The accused denied everything, said that he didn't touch her at all and that they had simply spoken on the occasion that they were alone together. And the judge said he didn't know who to believe, that each had given a believable account of what had happened, and so acquitted the accused. We also don't see very many cases like Raycroft, which was a case from Ontario that took place between 2015 and 2017. This was a case in which a woman married her second husband at the age of 69. She had met him through online dating. And she alleged to police that over the course of their 3-year marriage, her husband had both physically and sexually assaulted her. Her husband was very well connected in their small community. He had been the deputy mayor, and he claimed that she was a gold digger, that there were no assaults, and that she was motivated to lie because of financial disputes they were having about his farm. This case had an odd procedural history, with the accused being convicted at his first trial, the case being handed over to another judge for sentencing who refused to enter the conviction, declaring a mistrial, and then a second trial in which the accused was ultimately acquitted based on the judge's finding that there were inconsistencies in the complainant's testimony and he couldn't be satisfied of her guilt beyond a reasonable doubt. And so what the contrast between these cases tell us and how rare those latter cases are is that, first of all, the criminal justice system simply does not address in any meaningful numbers the most common forms of sexual assault against older women. Sexual assault by spouses or by acquaintances like neighbors against women living in their own homes. It's also very difficult to find cases of assaults by caregivers where there are no witnesses, no third-party witnesses to the abuse. And this presents a real problem because most sexual assaults do not involve additional injuries or witnesses. We also can see that where cases do look more like the typical sexual assault, that it's very hard to get convictions. And in both of those cases I mentioned to you, both in Lee and in Raycroft, the accused were acquitted. So overall, what we know is that there is a lot of work to be done. We need to both reduce the barriers to reporting across the board, but particularly for the most underreported sexual assaults. And we need to make it worth reporting by removing barriers to prosecution and to conviction. And we need to recognize that older women should not be siloed, that this is part of the larger struggle for sex equality in the criminal trial process for sexual assault cases more generally. So we see many avenues for future research here. We really need to develop clear empirical measures of the incidence of the sexual abuse of older women in Canada. Empirical measures that look both at lifetime prevalence and the cumulative effects of sexual assault across the lifespan. We need to disaggregate this particular kind of assault from other forms of elder abuse for the purposes of this data. And we also need to evaluate the choices that we are making about the regulatory environment for care providers and the risk of sexual abuse. It's clear to us that sexual abuse prevention needs to be at the forefront in terms of regulatory decision-making about how care for older women is provided. So that's a lot, and there's certainly a lot more work to be done. I'll stop there and turn it back to Benedet if there are any questions in the few minutes that we have remaining.
Thank you so much, Janine and Isabel. So I haven't seen any questions come in through the chat box just yet. This is a reminder to anyone who is on a computer. Feel free to type out your question. I will read it out loud. Anyone else who is only on the phone and not a computer, if you want to speak, use the little raise your hand button on your control panel and I will unmute you so you can ask your question. And once again, if you would rather ask your question later on, you can either email me or email Janine and Isabel directly, and we'll be happy to take your questions. Ooh, I see a hand. Grace. Hi, Grace. Go ahead and ask your question. Grace, you're unmuted.
I just want to thank you for having this information. I really got a lot out of this.
Thank you very much. All right. Anyone else? I think there's a question in the chat box. Just a second. Oh, here we go. We have a question saying sexual assault investigations are difficult to investigate and prosecute. Are there any suggestions on how police could build better cases for prosecution?
So it's Janine. Maybe I'll just offer a few thoughts there. You know, part of it is moving quickly. There's a particular need when we're talking about older women, and especially you know, what are sometimes called the old women who are quite elderly. To move quickly while memories are better, while evidence is still fresh, and to not let these cases languish. There is a need to collect evidence beyond the testimony of the complainant, if we're being realistic here, and to look for any other evidence that might be out there, other victims, because in many of the cases that we saw that went to trial, they really only could proceed when it was clear that there were multiple victims of the offenders. But it's also important, I think, for police not to simply assume that the criminal justice system, you know, has nothing to offer to these victims, and that these are better dealt with as a kind of social work issue or as an issue internal to care facilities.
Right, and I'll just add to that, you know, these cases have to get to the police for the police to be able to do anything about them. And, you know, when we're seeing barriers at the stage of the institution and at the stage of the family in even getting these cases reported to police. So one of the things we want to look at in the future is how much of this is non-reporting and how much of this is the police not adequately responding to that non-reporting when it happens. Sorry, police responding to the reporting when it happens.
Thank you so much. I have a few more questions that have come in for you. One from Sabrina asking if the whole study is published now.
Yes, it is in the McGill Law Journal. I'm just going to get this. It's in volume 62 in 2016 of the McGill Law Journal. We can send out a link to that. I'll see if it's available online and send out a link. I also have a PDF copy that I could share with Benedet about for people who are interested in a copy.
Wonderful, thank you. We have a question from Wego asking, is ethnicity an issue related to assault and or to persecution?
That was difficult for us to identify in the context of our study because it's only sometimes reported. We did find a significant number of both Indigenous accused persons and Indigenous complainants, but that was more for women living in the community. I don't think we have any of that information at all for women in long-term care facilities. I don't think that was even mentioned in a single case. And that's one of the difficulties in getting data on ethnicity in the criminal justice system is you depend upon whether the court's going to mention it and give you that information.
Or you're left to speculate based on, you know, on other kind of collateral details. But because in general, you know, complainants tend to be identified only by their initials, you have very little to go on in trying to determine the race or ethnicity of complainants. And that's a real problem because I think it is logical to assume that there are, again, intersectional barriers of age, sex, and race or ethnicity that need to be explored.
Thank you. And I think we actually just answered the next question, which was from another Janine, asking if there were any data collected on the race of the women involved in these cases. Next question from Kathy. Is it possible to use the information from these slides to recreate for an elder abuse response team? I'm going to go ahead and say yes, provided Isabel and Janine are okay with it too.
Yes, as far as I'm concerned, yes.
Absolutely.
Great. And just so you know, Kathy, I will make the slides are already available in the materials section of your little control panel, but I'll also upload them in French and in English on cnpa.ca sometime between this afternoon and tomorrow. So you'll have access to them there as well if you want to share with anyone else. Linda is asking.
Just one thing I wanted to say about the response to this problem is that another area that we want to do more research on is the long-term care facility, because just to highlight the fact that the only cases that made it to trial were when sexual assault was witnessed, and that is a tiny minority of cases. People take significant steps to make sure when they are sexually assaulting someone, to make sure that they are not seen and not witnessed by a third party. So dealing at the institutional level is just a huge problem that needs more work.
Thank you. There was a question from Linda asking, could the presenters comment on the concept of mandatory reporting?
So I can say just a couple of things about that, and this isn't an issue. Again, I think this is something that's in next steps for us to look at. But one of the things that really struck me about Ontario, which is a province that has at least some mandatory reporting requirements in the regulations, is that I thought, well, that's terrific. I'm going to be able to find this database with all these cases, and that often those reporting requirements were complied with in the most minimal way possible. And so we would see a categorization of something as that we knew from the case was actually a fairly serious sexual assault by one resident against another, as being reported as resident was found in a part of the facility to which they should not have had access, right? And that's how it was described. So I do think if you have mandatory reporting, to make it meaningful, you have to craft it in such a way that you deal with the institutional pressure to downplay incidents of abuse, to classify them as something else, to kind of somehow protect the privacy of the complainant by not, and possibly the other resident, by not calling them sexual. So mandatory reporting is useful, but it's got to be crafted carefully in order for it to be meaningful, I think.
Great. We have another question from Lori saying, well, first of all, thanking you for the presentation and asking if the new third-party reporting that is now available in Manitoba, is there an appetite to expand the service to other jurisdictions? Do you happen to know?
I mean, I think that there has been some move to expand that to British Columbia, but just to say that we've always had third-party reporting. The challenge with third-party reporting is, are you going to get enough evidence for the Crown to lay a charge and to meet the charging standards that are required? So, I mean, what we saw essentially in a lot of these cases was third-party reporting in the institutions where women had dementia. It was not the complainant reporting any of these cases. So I'm not sure that that's going to make a big difference, given that that's already going on and given that we have to give the Crown enough evidence to meet the charging standards that allow for charges to be laid.
I think, and just in terms of people who maybe aren't familiar with that term, I mean, sometimes it's used to refer to the practice of either the complainant or an advocate or support person for the complainant making a report to police of a sexual assault, but asking that it not be acted on, that it simply be held until further evidence can be gathered or until someone else comes forward. And I think it can be very useful to have a third-party reporting system of that kind if what you're trying to do is find out if there are multiple victims who might not be willing to come forward individually, but might be willing to come forward if they know that they're not the only one. The problem with that is that we have to trust the police to actually keep that information and to connect the dots, particularly when victims may be reporting in, different cities or different detachments. And so far, the police have not really lived up to expectations, in my personal opinion, in terms of that kind of, investigative integration and in that kind of persistence. So I just worry that those reports are put in the file, never to be heard from again.
Okay, I see more questions coming in. Sorry, we're going a bit over time, but I think it's worth it. Question, how would you suggest that we mitigate the issues related to care? For example, if the offender is the caregiver and gets arrested, what do we do with the victim to ensure they are supported and cared for? That's a tough one.
Yeah, no, that is a tough one. And I mean, of course, it depends on the context we're talking about. I mean, that's what we didn't see, right? Are women in the community reporting sexual assaults by their caregivers. And for the very reasons that question identifies, that women may be afraid that if they report their caregiver, that they will not have access to care. I guess, I mean, my concern is that that's not really care at all if they are being sexually assaulted, and that it's the responsibility of the various social service agencies to provide that support and to be monitoring caregivers and making sure that women are being cared for safely.
And as part of the research for this project, I was fortunate to be able to have an interview with the seniors advocate here in British Columbia, Isabel McKenzie, who herself ran a home care business for some time. And one of the things she pointed out to me is that it can be very difficult for caregiving agencies to fire or have any kind of employment consequences for workers where there is no criminal complaint. And so those things are often tied. Where the caregiver is a family member, that's a particularly challenging scenario. And we know that's true for younger women as well. It's very hard for a mother to come forward and report that it's her son that is sexually abusing her, possibly in conjunction with some kind of financial abuse. And that was a pattern that some of the frontline rape crisis workers mentioned was something that they had seen. So, there really has to be the ability to imagine some different way of living, and the supports have to be very clear and very accessible for women to take the step of accessing them.
Thank you. Okay, I will read out their 2 more questions, and then I will let everyone go and invite anyone else who wants to ask questions to contact either me, Isabel, or Janine afterwards. So I have a question from, let's see, Christelle. Is ability to speak English for older women a barrier to reporting? Do you have any data regarding the language of in the cases that you were looking at?
No, we don't have specific data because, again, that's often not mentioned because of attempts to protect the privacy of the complainant. What I will say is that, we've seen other cases and a number of cases in this study where women cannot communicate at all for reasons other than language. In the criminal justice system, that should not be a barrier, but in terms of women feeling the ability to trust and come forward to police, I suspect that that is a significant barrier. But again, we don't have that data from our study.
All right. And one more question from Pamela, and then whoever else had a question and did not, that did not get read out loud, I'm going to save those questions and forward them to Janine and Isabel later on, along with your name and contact information. Okay, so last question that I'm going to read out today. Did you see a difference in Ontario between long-term care homes and retirement homes handling of abuse reports? There are two types of residences with mandatory reporting, but they are very different, one being private for-profit businesses, the other one being a healthcare facility under the aegis of the Ministry of Health and Long-Term Care.
Yeah, that's a really interesting question. That's not what our study focused on, in part because I think in large part because we're legal scholars, and what we wanted to look at was what cases are making it to trial in the criminal justice system. So that was the focus of our study, and as part of that, we wanted to compare that to what information was available about the patterns of sexual assault of older women. So we didn't research the mandatory reporting empirically, but I think that could produce a very interesting study, because my hypothesis is that where these care facilities are effectively businesses, where they are marketing a kind of high-end seniors care experience, there are clear incentives to minimize the extent of abuse that happens in the facility. It's not good for business, and it's not that they don't care about the residents, but it's actually, it struck me how similar the incentives are for universities, and so that's a good reminder that older and younger women are not always so different in these areas. That universities have a real incentive to market a product to parents that says that their campus is a safe place for young women, and that's true for long-term care homes as well. But it would be interesting to see if whether the publicly funded ones don't just, don't still have a variation of that same kind of pressure of not wanting to admit the extent of what might be happening in the facility.
Okay.
And sometimes, subject to what Janine mentioned about the seniors advocate, sometimes you see cases where accused persons have been fired from one facility and moved on to another facility. And that's a largely irresponsible response to these kinds of problems, because firing someone from one facility may help the residents of that facility, but doesn't bode well for that person's future workplace. So, we sort of looked at cases in labor law and in arbitrations and in various other areas, trying to find cases where we could find more evidence of this, and they simply weren't there. And my guess is that even if we did do that work in Ontario, we found 14 cases involving 18 women across 20 years in all provinces and territories. So just the numbers of prosecutions are so small that it's really difficult to draw those kinds of conclusions.
Thank you. I actually have just one more question. It's the last one that came in from Jamie. Did you see a difference in the number of reports in the provinces that have AP legislation compared to those who do not?
Again, no, because we're not looking at reports. We were only looking at cases that made it to the criminal justice system. And again, those numbers were so small, less than one a year anywhere in Canada, that it was just impossible to draw those kinds of conclusions.
All right. Well, I think that's it for the questions for today, because I know we've gone over time, but thank you so very much for everyone for asking wonderful questions. It was really, really interesting. And thank you both to Isabel and Janine. If you are still online, you can see the slide where you can find my contact information if you wish to connect with me, our social media information, as well as the link to this project page on cnpa.ca. Visit it regularly. We'll add more resources and details as the project develops over the next 2 years. Isabel, Janine, thank you so much. It was a really, really informative presentation. And everyone, you will be receiving a copy of the recording tomorrow. You have access to the materials through this platform, and they will be also available on cnpa.ca. Thank you so much, everyone. And
perhaps I'll just send you a copy of the paper, and that could be posted with the PowerPoint slides if anybody did want a copy of that.
Absolutely. We'll add that to the website as well. Thank you so much. All right.
Thank
have a great
you
day,
very
everyone.
much.
Thank you.
Bye-bye.
Bye.